This is important, not just for MLAs, but for all islanders. And I believe that the well-being of our democracy in our province is at stake. I don't think it's hyperbolic to say that this bill, in its current form, threatens some of the fundamental democratic principles that we as islanders and Canadians hold so dearly. Because during the lead-up to the first plebiscite, there were broad public consultations as part of an open and a transparent process. The Premier promised the same thing for the second plebiscite, but instead, Bill 38 was drafted in secrecy. By speaking on the principles of this bill at second reading, I am in part trying to provide some of the public input that this bill is utterly lacking. The dates attached to the legislation have been artificially generated to create a false sense of urgency for passing this bill. It reminds me somewhat of those cagey salespeople who insist that you must sign a contract today or the special deal you're being offered is not going to be available to you tomorrow. Mr. Speaker, I make it a policy to never sign a contract, and this one, by the way, is a doozy, without actually reading all of the small print. And the people of Prince Edward Island deserve the same from their elected representatives. When we apply the idea of a level playing field to this bill, we must consider a few things. Firstly, we have to consider the timing of the next election. That regardless of how perfectly flat the playing field is, the game is decidedly rigged if only one team knows when that game is actually scheduled. Secondly, we must consider the idea that status quo always has the home team advantage. It takes a lot more time and a lot more energy to explain a new system to voters than it does to describe the virtues of a system that they are already entirely familiar with. So, ensuring that both sides get equal amounts of money with no option to spend above and beyond that amount does not necessarily make the playing field level. Thirdly, we have to consider the issue around proponents being allowed to raise money. Would the government or the opposition members be comfortable if instead of being allowed to raise money for the next election, they were told that all registered parties would be given $400,000 to run their campaigns? Now, you might imagine that I would personally be very happy with that model, because it would certainly level the playing field for the Greens, who have never, of course, had the advantage of accepting union or corporate donations. But I would also acknowledge that it would put far too many limitations on our ability as citizens to participate in democracy. So, instead of having fixed set amounts, why not have referendum campaign finance rules similar to the ones that this government has recently proposed for political parties? Your idea. No off-island money, no corporate or union donations, and a fixed maximum donation per person. I have never opposed having rules around funding the referendum campaign, but I think they should be fair and somewhat equivalent to the ones that we envision for other forms of political campaigning. Fourthly, we must consider the necessity for a piece of legislation that just covers this one particular, precise, singular referendum. To return to the soccer analogy briefly, how fair would it be during the World Cup finals if one team was allowed to decide that a completely different set of rules should apply in the final round? Right up until the moment the Attorney General came to our office the other day to brief us on the bill, the third party had no idea whether or not government was proposing a referendum bill that would apply to all referendums ever held on PEI forever going forward, or whether it would apply specifically to the electoral reform system. And it turns out, Mr. Speaker, that it is the latter. This bill is specifically designed for this one singular referendum. And I wonder, would the government be so fond of this act if they knew that future referendums would all be run in this way? The fifth thing we have to consider when discussing the levelness of the playing field is whether this legislation could withstand a charter challenge. Since any legislation that violates our Charter of Rights and Freedoms cannot, by definition, produce a level playing field. Now, Mr. Speaker, I'm not a lawyer, but I have been hearing from many of my constituents, and many of them, including some lawyers, do not think that this Act would withstand a charter challenge. The concerns I have been hearing relate to potential violations of Section 2B of the Canadian Charter of Rights and Freedoms, which states that everyone has the fundamental freedom of thought, belief, opinion, and expression, including freedom of the press and other media communication. I have also, Mr. Speaker, been inundated with links to case law on the Canadian Legal Information Institute, where the issue of Section 2 rights have been tested in court. And earlier this week, I tabled copies of 4 of these court decisions. Now, I have to assume that part of the considerable effort, as stated by the Minister, included seeking a legal opinion on the constitutionality of this incredibly important Act. I really don't care whether the opinion comes from outside or from an on-staff attorney with the department, but I do care if none was sought. And based on the Premier and the Attorney General's reluctance to table the document, I can only assume that either opinion wasn't sought, or that they have an opinion, but that it does not support the legislation. I have grave concerns that without confirmation that the law governing this so-called referendum is in fact constitutional, we will find ourselves in a state of even greater uncertainty, Mr. Speaker. So far, the Premier has failed miserably every step of the way on our journey toward democratic renewal, and I fear that he is leading us into yet another dead end. First, the Premier assured that he was open to electoral reform and initiated a broad, open, and even successful public consultation on the issue. He and everyone in this legislature endorsed the process to conduct a plebiscite. But when the results didn't suit him, he made an executive decision to reject the results, to overturn the will of Islanders. He then rashly promised a binding referendum during the next general election, even though he knows that violates the principle of parliamentary sovereignty. He next stayed as silent as possible on the whole issue, arrogantly batting away serious questions during question period. And then, suddenly, out of the blue, with no consultation, no public input, and not even a proper debate on Motion 43 in this legislature, the Attorney General tables Bill 38. Mr. Speaker, let's pause for a moment and think what might happen if government does manage to force through this legislation without fully addressing the issue around the constitutionality of the Electoral System Referendum Act. The legislation will pass. The process to appoint a referendum commissioner will be rushed, secretive, and it will undermine public confidence. Individuals and organizations who question the legitimacy of the Referendum Act may seek a judicial injunction or even begin the process of a charter challenge. At some point that is convenient to the Premier, an election will be called. A vote may or may not be had during the general election, depending on whether the court injunction I mentioned earlier has been successful. And assuming the vote actually goes ahead and the proponents of proportional representation win this vote with a majority of referendum votes cast, but not the majority of electoral votes cast, and I'm not going to get into that rabbit hole, the next government will have to decide whether or not to honour the results of the plebiscite. Because the rules around whether to honour the vote whether or not it would be binding are both bizarre and almost certainly unconstitutional. So, we will be left with a Premier, whoever she or he is, once again having to make an executive decision on whether or not to honour the vote. If those who favour first past the post have a clear majority, there will still be no electoral certainty, as the Charter Challenge will continue to work its way through the courts. What a mess. A continued mess. 2 years of mess, and it's not getting any better. Once again, A huge amount of taxpayers' money will be expended with no clear result in the end. There is a word to describe that process, but I've already been told that it's very unparliamentary. From the tight advertising rules, to the formation of the question, to the calculation created to determine if the vote is binding, it looks like Bill 38 was designed in the back rooms of the Liberal Party to protect their own privilege. But if the bill has been written to maximise the benefit to the Liberal Party, shouldn't it then be the Liberal Party that takes on the financial and moral risk of defending this bill in court? Yet, in spite of all this, the Attorney General smiles and chuckles and ducks questions and refuses to tell us whether or not government has obtained a legal opinion on the constitutionality of his own legislation. I find this the least amusing matter that I have almost ever encountered in this House. Mr. Speaker, there is so much more that I could say about this bill. However, I fear that I may have already tested the patience of some in this chamber. I believe my comments over the past couple of days have provided ample proof that Bill 38 is simply not ready for debate on the floor of this House. Therefore, I recommend that the bill be sent to the Special Committee on Democratic Renewal for further study and public consultation.